welcome you to the January 24, 2022 settings of the 7th Court of Appeals. I like your haircut. I like your haircut. I have to take advantage of that every once in a while. So. But people with hair, I'm not holding it against you. But again, thank you for coming to the January 24, 2022 settings of the 7th Court of Appeals. We appreciate your journey to Amarillo. I think you've picked a pretty good day. It was a little tougher last week, and it's pretty nice this week. So I hope you've had the opportunity to enjoy Amarillo a little bit as well. It's a great little town. We have one case for this afternoon, and we'll go on and call it. Since you're the only case, I will dispense with asking for announcements. You're here, and we'll just proceed. And I will not give any admonitions other than please answer our questions. That always helps facilitate the argument. We have 07-21-00016-CV, Stonewater Roofing Ltd. Company versus Texas, and the representing Stonewater. And please identify yourself.
Good afternoon, Your Honors. My name is Chase Coburn for the plaintiff in this case, Stonewater Roofing. With me today is my co-counsel, Michael McCabe. And
would you be providing all the arguments?
Yes, Your Honor.
Okay. No tag team or anything.
It's 20 minutes to start and 5 in rebuttal. Okay, thank you, Your Honor.
And it's not one of those where we say whatever, you do have 5 rebuttal no matter what.
Great, thank you so much.
Okay.
May it please the Court,
Yeah.
and good afternoon. States cannot restrict speech by calling it professional conduct. Professional roofing contractors like Stonewater want to speak freely with their clients and their clients' insurers, and whether they can do so without violating the Texas Insurance Code depends on what they say. The question before this Court is not whether the statutory provisions at issue violate the First Amendment, that we believe they do. The question at this stage is simply whether they are subject to any First Amendment scrutiny at all. To affirm the trial court's dismissal under Rule 91A for no basis in law, this Court would have to hold that the provisions are wholly exempt from First Amendment scrutiny. That is the state's position. The state contends that the statute avoids the First Amendment entirely, as long as it labels speech the practice of public insurance adjusting. If that were true, then the First Amendment would not protect speech falling within many other state-defined practices, including medicine, law, education, veterinary care, surveying, or psychiatry, all of which have been found in recent years to implicate the First Amendment. And it's easy to understand why.
Counsel, just to clarify something in my mind. Is there, in your view, anything left of the regulating conduct with incidental impact on speech theory line of cases, or is that all out the window?
You're asking if that theory, whether the speech in this case is incidental?
Just in general. Is there anything left of the rule of law that balanced conduct, regulating conduct that has incidental impact on speech?
Yes, Your Honor. I believe that is a consideration the Court makes after it's engaged in whether this is a content-based law. It would consider whether the regulation of the speech is direct or incidental. And if it's incidental, it would still be subject to First Amendment scrutiny. It's a lesser scrutiny.
You said the intermediate standard.
That's correct, Your Honor. But that's a question that's secondary to whether the law is content-based or content-neutral. Does that answer your question, Your Honor? And if I could go back to why these courts are finding the practices, regulations of speech in the context of professions to implicate the First Amendment, if it didn't apply to occupational speech, then states could restrict any speech they disagree with by simply defining or redefining speech as professional conduct. And there's many situations you can imagine where this would be deeply problematic. You know, for instance, doctors could be punished for voicing an unpopular opinion on COVID-19 simply because that would be considered medical advice within the context of practicing medicine. Attorneys could be punished for publishing or presenting opinions on a range of controversial subjects as long as it falls within the state-defined practice of law, but states can't opt out of the First Amendment.
Well, there are already restrictions on what attorneys can tell their clients, right? I mean, the U.S. Supreme Court decided within the context of a bankruptcy code provision a few years ago after BAP-CIPA was passed to say you cannot instruct potential bankruptcy clients to take certain actions in anticipation of filing a bankruptcy. My understanding is the U.S. Supreme Court said that was okay. That didn't run afoul of the First Amendment.
That's correct, Your Honor. You're referring to the Milovitz case,
Right.
and that, importantly, in that case, the First Amendment did apply. This was after determining that the First Amendment applied, the court engaged in the traditional First Amendment inquiry, whether the government interest was sufficient to justify the law, and it found that it was in that case. But here, we haven't reached that inquiry yet. We're at the threshold question of whether this even implicates the First Amendment.
Which provision are you saying is unconstitutional? I guess that may be part of where I'm a little bit confused about three, because part of what I'm looking at is 4102.163. It says a contractor may not act as a public adjuster.
Yes, Your Honor. So it would be that provision. It would also be the prohibition on the unlicensed practice of public adjusting. But importantly, it's because of the definition, okay? It all goes back to the definition of public adjusting, and that is in .001, 4102.001. And we're getting a step ahead of ourselves a little bit to talk about, how they could correct this, how this could be fixed, what the remedy would be. But if I could just give one example, in the unlicensed practice of law context, there was a case litigated many years ago in 1999 over the unlicensed practice of law statute. A plaintiff brought a similar lawsuit to the lawsuit that we brought in this case. And the federal court in that case, Northern District of Texas, held that the law did plainly implicated the First Amendment, the unlicensed practice of law statute that we're all familiar with. While that case was pending, the Texas legislature amended the statute and carved out a big exception for people that want to say, look, we are not an attorney. This is no substitute for the advice of an attorney, and that mooted that entire case. We don't have that kind of a provision here. There's no disclaimer provision. My client can't tell a consumer or an insurer that we are not a public adjuster and avoid violating this law. There's nothing they can do to avoid violating it, and getting into the vagueness issue, they don't know when they have violated it. That's a major distinction from the unlicensed practice of law.
What makes this First Amendment in a nutshell?
I'm sorry, Your Honor, could you repeat?
What makes this First Amendment in a nutshell?
What makes this the First Amendment?
In your view, what implicates the First Amendment? Before
Yes,
we
Your
even
Honor.
go to the second test, looking at conduct versus incidental impact.
Yes, Your Honor. So I would start with the text of the statute. If we look at the definition of public adjusting under 4102.001, 3, we see that we're looking at a prohibition on conduct that is inherently expressive, negotiating for a specific purpose, affecting an insurance claim settlement, acting on behalf of clients, advertising, soliciting the contractor's ability to do so. It's impossible to engage in any of these activities without speaking. We can't know whether you violated these provisions unless we know what you said. All of that directly implicates speech. And if there's any question after looking at the face of the statute, TDI's official guidance on the interpretation of the statute, which we cite in the petition, we quote it in the petition, so it's part of the record in this case on a 91A motion, it purports to delineate what contractors may or may not discuss, that's their language, discuss pursuant to the law. And this issue about whether the law actually touches speech and speech triggers the statute, that's undisputed. The state in its motion said, and I'm quoting out of clerk's record page 62, it's the alleged contents, that's the state's language, the alleged contents of what Stonewater said that implicates the statute. That's why they violated the statute. We believe these admissions should end the inquiry because the law is indisputably content-based. The case should be reversed and remanded for First Amendment scrutiny. And I would like to bring the Court's attention to a case that's not cited in the brief, but has come out in the last year. I think it was during the briefing, and we're happy to submit something to the Court on this afterwards, but it's a 2021 case in Florida.
Can you give us the citation?
Sure, Your Honor. It's, the site is 2021 WL 3046800, and this...
Any chance you happen to have the Lexus citation?
I don't, Your Honor. I apologize. I can submit it afterwards.
What's the style? What are the parties?
It's Gale Force Roofing, and I don't have the other party. I apologize, Your Honor. We're happy to submit something into the Court afterwards. Gale Force Roofing.
G-A-L-E.
That's correct. This case did involve a prohibition applied to contractors and public adjusters, and it isn't the same provision, but it's actually a less restrictive provision. It was prohibiting advertisements for contractors and public adjusters, quote, for the purpose of making an insurance claim for roof damage. That was it. The federal court in that case, is 2021, entered a pre-enforcement injunction against that law after applying intermediate scrutiny. There was really no dispute that the First Amendment applied. That was a foregone conclusion. It wasn't really litigated. The opinion doesn't talk about it, and the opinion is mainly about this balancing test of whether they can meet the standard, whether they can meet the scrutiny required to uphold the law. But nevertheless, it shows that even a less restrictive law, that law didn't touch in-person communications. That law didn't touch negotiating and getting on the phone and talking to the insurer and trying to work out whether the contractor is going to get paid. It didn't talk about any of that. It talked about advertisements, commercial speech alone. And even in that case, the law was presumably unconstitutional under a lower scrutiny. And that's not, again, that's not an anomaly decision. We have other cases we've cited in the briefs dealing with veterinary medicine, surveying, psychiatry, teaching. All of these kind of post-NIFLA cases are kind of routinely now applying the First Amendment without question to occupational licensing schemes. But in many cases, they are content-based, they're struck down. And that is a more recent development since NIFLA. Now, the state agrees that the professional speech doctrine is dead. That's their language in their appellate brief, page 15. But the 91A motion relied on that same premise. The 91A motion stated that generally applicable, I'm quoting from pages 58 through 59 of the clerk's record, generally applicable licensing provisions limiting the class of persons who may practice a profession cannot be said to be a limitation on freedom of speech subject to First Amendment scrutiny. That's a direct quote from a 1985 decision, and it's a concurring opinion by Justice Byron White in the Lowe decision. That is really seen as kind of the origin of the professional speech doctrine that many courts had adopted. The Fifth Circuit had adopted it. And at the time that this law that is under review right now was passed, the Fifth Circuit had held that if it's in an occupational licensing scheme, it's outside the First Amendment. NIFLA abrogated all of that. NIFLA rejected this principle from Lowe. And many cases, including cases cited in the 91A motion, have been completely abrogated after NIFLA. If we look at page 60 of the clerk's record, the state is relying on a Hines decision. This is a Fifth Circuit decision that was later abrogated after NIFLA. So it just goes to show here that the issue is really the state is relying on an outdated, bad law that is no longer in effect after NIFLA. And after NIFLA, this is not only implicating the First Amendment, but it's subject to strict scrutiny. And lastly, on the First Amendment, these restrictions are not incidental, they're direct. Restrictions on speech are incidental when the violation of the law is triggered by non-expressive conduct. So the classic example here would be a burn ban, right? If I'm lighting a fire, that's not inherently expressive, okay? I'm triggering the application of the law by lighting the fire. Now, if I'm lighting the fire for some political purpose, if I'm burning a flag, that changes the analysis a little bit, and now we're dealing with an incidental burden. And again, even in that instance, the First Amendment still applies. Lower scrutiny, but still applies. Here, we're not talking about triggering the application of the law with non-expressive conduct. Everything we've talked about in the statute, negotiating, affecting, acting on behalf of, soliciting, advertising, it's all expressive conduct. It's direct. And, you know, I would direct the court to the Otto decision.
You're saying because it's, or you suggesting that because it's direct conduct, it takes it out of the category of incidental?
Yes, Your Honor. Yes, Your Honor. This is after we would have already decided that the First Amendment is implicated, and it's a question of whether it's direct or incidental. That helps us determine the level of scrutiny that would be applied to the law on review, and that's intermediate scrutiny for incidental, which I believe is undisputed.
More of a minor as opposed to indirect, doesn't it?
I'm sorry, Your Honor, can you repeat your question?
Incidental, to me, connotes minor, incidental, not much. Whereas direct, the anonym would be indirect, and those are two different things. Minor and indirect aren't necessarily the same.
I would agree with that, Your Honor. I think that...
I guess, do you have a case that says if it's a direct impact, it takes it out, intermediate standard cannot be met?
Well,
it's no longer incidental if it's a direct.
and I just want to be clear, Your Honor, I'm not suggesting that it can't meet the intermediate standard. This is simply a question of which standard do we apply? Do we apply strict or intermediate?
So it can be direct and still meet the intermediate standard.
If it was direct, it would involve it would implicate strict scrutiny. If it was incidental, it would implicate intermediate scrutiny. That's the distinction that's been drawn. And I think a helpful analysis for the court... Go ahead.
And that's cited in your brief, yes?
Yes, Your Honor. Yes, Your Honor. And the Otto case in particular, that of the 11th Circuit, this is a 2020 decision. It was dealing with a law where the government tried to ban so-called conversion therapy, and the government said, look, this is just incidental to medical practice, okay? The 11th Circuit vehemently disagreed with that analysis, and they said, if speaking to clients, which is what the law regulated, if speaking to clients is not speech, then the world is truly upside down. So it's really a pretty simple analysis here. If the regulated conduct involves speech, it's a direct regulation of speech. The Supreme Court and the Courts of Appeal after NIFLA have made this issue much simpler. There doesn't need to be an abstract consideration of whether this is conduct or speech. We just look at whether speech triggers the violation directly. If that's what's happening here, as it is, and that's undisputed in this case, it's triggering the First Amendment and it's subject to strict scrutiny. It's really that simple. And I would lastly note that even if it was incidental, that would not be enough for dismissal of the entire case. Even under the O'Brien decision, which is when you get into this incidental regulation, you're dealing with an O'Brien situation where you would still apply intermediate scrutiny as we've discussed. So that would not be enough to grant a 91A motion for no basis in law. For those reasons, the court should hold that the challenge provisions are content-based regulations of protected speech, that they regulate speech directly and not incidentally, and reverse and remand for strict scrutiny under the First Amendment. Now, if I could quickly move to the 14th Amendment issue at the time that I have left, we think that this issue can be made pretty simple. If the court were to find that the law implicates the First Amendment, there's really no dispute that it also implicates the 14th Amendment as well. On page 30 of the state's appellate brief, the state appears to agree with Stonewater that the facial 14th Amendment challenge can go forward if the law is, quote, found to regulate protected speech, end quote. And that's consistent with Doyle, the Criminal Court of Appeals case in 2019 cited in our brief. Quoting from that decision, it says, when a vagueness challenge involves First Amendment considerations, a criminal law may be held facially invalid, even though it may not be unconstitutional as applied to the defendant's conduct. And as the court knows, that's really the state's only argument here. They're arguing that it's clearly prescribed. Our conduct is clearly prescribed, and therefore there can't be any basis in law for the void for vagueness challenge. So because there's no dispute that the law at the very least imposes an incidental burden on speech and therefore implicates the First Amendment, that should be enough to also reverse on the 14th Amendment claim as well. But just to be clear, we think the 14th Amendment claim stands alone regardless of the First Amendment claim. And primarily, we would say that the first reason is because this is not an issue that can properly be decided on the pleadings. The state's only argument against the 14th Amendment claim is that the conduct as alleged in the petition was clearly prescribed by the law. We think that's a fact question that should not have been resolved on a motion to dismiss. Doyle, again, out of the Criminal Court of Appeals, footnote 30 of that opinion, says, as applied challenges generally require fully developed records from trial. The authority that the state is relying on to support its argument, all of these cases involved fully developed records. The Holder decision was decided on summary judgment evidence. The Hoffman Estates famous decision was decided after a bench trial. So we don't know of any case that decided an as-applied challenge under the 14th Amendment on the pleadings, and we think the court can reverse on that ground alone without getting into the dispute over whether or not the alleged conduct is clearly prescribed by the law. But even if that can be resolved on the pleadings, we think that the allegations in the petition, if they're taken as true and construed in Stonewater's favor, the idea that Stonewater's speech was clearly prescribed is easily refuted. Stonewater did not call itself a public adjuster, and Stonewater had good reason to believe that it was not acting like a public adjuster when there was a public adjuster on the same transaction. The underlying transaction, the consumer had hired a public adjuster, and this is all alleged in the complaint. This is all part of the record. And the question about clearly prescribed under Holder, it goes to, well, did the defendant have good reason to know that they were violating the law? Was it clear? And we don't think it could be clear to Stonewater, who is on a transaction with another public adjuster on that very same transaction. And finally, I would ask the court to look no further than TDI's own official guidance, where it is very unclear what can be discussed and what can under the statute. And I see that my time is expiring, and I'll save the rest for rebuttal. Thank you.
Good afternoon. May it please the court. My name is Sumner McDaniel, and I represent the Texas Department of Insurance in this appeal. From the onset about this case, Stonewater makes much about the negotiating and the effectuating settlement language that is found in the definition of public insurance adjusting. But at the heart of the question and the matter that the court must answer today is whether or not the regulations and the public adjusting prohibitions actually target speech, and they actually implicate the First Amendment. Looking at the content of the speech does not occur if the regulation simply regulates conduct. And here, the regulations do just principally regulate conduct. The first statute, 4102.051, is a mere licensing requirement. States can license professions as they please. That has been the case and the law of the United States and in Texas for decades. And all it states is a person may not act as a public insurance adjuster or hold himself out in this state as a public insurance adjuster without a license. To hold...
Apply here, though? That's a theme of your brief, without a license, but the statute prohibits a contractor from publicly adjusting, irrespective of whether they have a license, doesn't it?
It does in 163. In that instance, Your Honor, that is a hypothetical that certainly could be a closer question about whether or not that implicates speech. But we don't reach that question today because Stonewater admits they don't have a license. So they're already in violation of 051 by simply not having a license and practicing as a public insurance adjusting, if that is what they're...
If they get a license, it's still in violation.
Under 163, that would only come on when it comes to advertising to adjust claims on the same property in which they are also contracting for that property. And that's a much more narrow question, Your Honor, but it is not before the court today. That question simply isn't here because Stonewater doesn't have a license. It's a hypothetical plaintiff that isn't before the court, and that question need not be answered.
I don't guess I understand that. You're saying a contractor can't act as a public adjuster. That's 163. And we've got what a public insurance adjuster is defined as under 4102.001 sub 3.
Yes, Your Honor. 163 is specific to, and it states clearly, may not act as a public adjuster for any property for which the contractor is providing or may provide contracting services. So it's specific to that, to services in which they're also practicing as a public insurance adjuster and a contractor. They are free to have both a public insurance adjusting license and can act as a contractor on separate properties. That's 163. But they don't have a license. They admitted as much in their pleadings, that they do not have a license.
Well, did I completely miss the boat? They don't claim to be a public adjuster either.
Correct, Your Honor. They don't state exactly that they are a public insurance adjuster, but that's kind of the point. They're saying that the public insurance adjusting here violates the First Amendment because they need to have a license to do what they're doing.
Well, they're saying your definitions